So I'd like to take us back for just one moment on the revenue sharing discussion and bring up again the question of priorities to see if there are any comments. When you have limited funds, which obviously we're discussing, do you wish to comment on how you will share those revenues? Because it is one of the key issues. We can all not speak at the same time. Ms. Garfield.
It sounds, and I think that the clause, when there aren't enough resources to go around, how do we allocate resources to projects that have different meanings for different groups? And the first one that comes up, and we've just started talking about, is the habitat conservation, is if we don't think that it's a reachable goal that has been set by others for us, what are we going to do? I mean, so that's kind of, we all have the same vested interest in figuring out what are we going to do if we can't meet the goals set by other agencies for us. So that's one scarce resource. And the second one's going to come up on roads, is that we've already had a drive-by on that discussion about where investments should be made that are equitable across all of them. So we're not going to have enough money to do all the roads that everybody wants done in the time frame that everybody wants them done. So we're going to have to figure it out. How are we going to do that? Rock, paper, scissors?
Additional comments? Ms. Parker?
Just a general comment that, you know, mitigations we're legally required to do. Mm-hmm. So I'd sort of start there. And some of, yeah, I guess I'll just leave it there.
Okay, and Ms. Reimers, did you have a comment also?
Oh, just on revenue sharing, and actually just overall philosophically, that as an entity, we're here today and in all the meetings and sharing the positions of the various jurisdictions, and that's what we are all about, is sharing where we stand and what we're going to be working on and working on the details. And from Carmel, we're just looking at an overall body that works together and solves the issues, and they are complicated, but I'm anticipating that we'll come to some resolutions going forward that will work for all of the jurisdictions. And that's what, I guess that's why we're here. We just want to be sure that everyone gets the support and the recognition and the opportunity to make their plans within the FORA reuse plan successful. So we're looking for success for everyone, and that means some give and take, and hopefully we'll be getting forward on those details.
Thank you. Any other comments on this topic of priorities when you have limited resources? All right, let's move on to the next, some discussion about the next key policy consideration, policy enforcement. What policies get enforced and how? And Ms. Damon gave specific examples of prevailing wage, veteran support, building removal. Any comments? Ms. Parker?
And I think earlier when Ms. Damon was talking about this, she mentioned that prevailing wage is a covenant that runs with the land. I think this gets back to what Supervisor Adams asked for, was kind of a clarity about the legal obligations, what policies and obligations run with the land. You know, I think that's an encouragement to follow certain policies, and anyway, I would start with that.
Okay, so if I understood your comment, that you're asking for additional information about which policies actually run with the land, is that, or which items run with the land, is that
right.
Correct?
So we've talked about the base reuse plan, the master resolution, So it would just, I think it probably would be helpful. It's not, I don't think it's new information, but I think it's going to be helpful for us all going forward to know which are the specific things that do, that we are legally obligated by accepting the transfer of the land to accomplish.
All right. Did you have a comment?
I do. Well, at least with respect to the policy enforcement bullet point that I've listed there, I've got prevailing wage, veteran support, and building removal. The only one that's part of the master resolution is the prevailing wage. The veteran support and the building removal are policies of this board. So those policies, unless you change something, create a new program, or do something else, those would not be covered under the concept of covenants running with the land. It's only those policies that are encapsulated in the master resolution, as that document would be fixed on for a sunset date. And my initial recommendation to this board as part of the transition plan is that that master resolution, those documents are recorded so that everybody is on notice of what those provisions are.
Okay, Mr. Edelman?
Yeah, I'd like to take what Supervisor Parker said and just one step further with regard to the prevailing wage. I'm not looking for encouragement. I want a legal determination whether or not it does or does not run with the land. If, as close as possible, we can come to a legal determination. If we have no choice, that's fine. If we do have a choice, I'd like to know that once whatever our transition plan ends up being.
Thank you. Ms. Morton?
So from the City of Marina's standpoint is that if we are going to continue, which we are demonstrating we are, to generate funds for a CFD for a base-wide plan, there are many policies that are in that base reuse plan. There's an Oak Woodland policy, for example. There's, when we talked about Eastside Parkway, there's a 150-foot setback from reserve areas that the county can't put its roads through or put developments through. City of Marina is looking for implementation of all policies. Don't just pick and choose the ones that get the most public scrutiny, but that you have many, many policies. There was a reassessment report in 2013 that went through and said, hello folks, here's where you are on your policies, here's what you haven't accomplished. It would behoove this board to be focused on, do we get those done? It's how many years later? Can we get those done before 2020? That was our job. So if those policies are important to us as jurisdictions, we should be bringing them forward and putting them on agendas and getting it done. Prevailing wage, our understanding in the transition task force from legal counsel, from Sherry Damons, who conducts those meetings, was the base reuse plan being recorded, included the master resolution, that those were covenants that run with the land. And that's part of why Marina is going forward with its plans on generating the funds to make sure that this happens. The other thing that's happened in the City of Marina that hasn't happened except with the county is that we've committed our tax increment into the future for the fulfillment of the base reuse plan. It's going to Marina Community Partners, which is part of the obligations in going forward with this plan into 2035. So I'm looking forward to that the county doesn't plan a road that doesn't have a 150-foot setback. I'm looking forward to a policy that favors everybody's best interest of what was agreed to in this plan, not just the burden of financing. Prevailing wage, we had a meeting with the senator. We talked about what our limitations were, even if that is a covenant that runs with the land. There was the issue about, and I think we've all identified that as a FORA board, we have no teeth for enforcement, that is a state issue that I look forward to working with the senator and the assemblyman on, is there something we can do statewide in the labor code to remedy the deficiency in enforcement?
Thank you. Other comments on this topic? Mr. Hulamar?
You know, And I very much appreciate the board's engagement in this issue, because much of what Councilwoman Morton has mentioned about base reuse plan obligations do have certain responsibility if the base reuse plan survives FORA. There's some real important ones. The two items that are on the board, veterans support and building removal, are things that are not included in the base reuse plan. They are independent decisions made by this board voluntarily to add support not required in state law or the base reuse plan to those two areas. The veteran support one has been very important to this board and region. And we, in fact, took over responsibility and advocacy for things at this board level that were not happening anywhere else, and that the veterans community asked us for that. So that endorsement, I think, will continue for another 23 months and 2 weeks. What happens after that, I think, is a question. And then there's another one about building removal. We have always reported to this board accurately that it's been the policy of this board that in every case, when a fair market valuation is done on building removal, the cost of removing the buildings is taken into account. So the final $10 million price, for example, on the Marina Heights project, took into account not just that fees would be paid and therefore a lower price, but also that buildings would be the obligation of that developer. In selected cases, like the Stockade and Surplus 2 in East Garrison, and a bunch of work still left in the Dunes project, the FORA board voluntarily added from its resources additional dollars to take down buildings and took the responsibility for taking them down. That was a policy decision. We believe we will finish what the current policy is by 23 months and 2 weeks from now. However, there's still other building removal obligations, even with all of that extra voluntary effort. And you sometimes get a lawsuit when you take that extra effort in some cases. But in addition to that extra effort, there's an additional request that FORA leave a very positive statement by finding a way to finance and assist more with the Dunes project and Surplus 2, so that we get the blight removed. See, I use the word blight sometimes. The building removal, as we call it, though, is something that this board needs to decide as a policy. What's the policy? Is the policy we're done at Stockade and the administrative committee has some things it wants to bring here? Or is the policy to do additional work because it would benefit everyone from CSUMB to Monterey to Castroville to make that happen? So that's the policy question on those two that are not part of the base reuse plan.
So could I just ask a follow-up question to you, Michael? I thought what you just said is really so informative to me. And others around the table may know all of that already. I'm just wondering if there is some place that we could find, or if we could have presented to us virtually a list of what FORA, the board, has committed to. And maybe this is your 2013 study, what's been completed, so that we know what's left that the FORA board has already committed itself to. And then what are those other things that that exist that is not part of the FORA board's decision, that is not policy, that is something that we would be looking at beyond that. But going to what you said about the policy specifically, extra money, extra things that were decided, I think it's important for us to know what that was, where it stands, and what remains outstanding. Then we could make, I think, a much more enlightened decision about what to do with it, where to go forward with it.
And Senator Money, thank you, Ms. Adams.
Thank you. And along these lines, a question for Michael or Sherry. So the fact that veterans and building removal are not included in the base reuse plan, would there be any advantage for this board as constituted now before the sunset date to amend the base reuse plan to articulate any commitment on building removal, for example, that when FORA sunsets, there would be some continued obligation on building removal that would help provide guidance to the county or the cities or developers moving forward. And I don't know if there's a simple answer to that today or something that we could explore, just whether using FORA as it exists to project or to build into the base reuse plan some ongoing commitment, let's say on blight removal.
So I'll give you my take on that. The way it's been discussed, right now we have a policy of the board that has said we are committed to removing buildings and we're going to use these certain funds to do that. That's capsulated in the capital improvement program. I think what's being envisioned at the admin committee is something where the board might consider changing its policy to say all building removal, and we will dedicate these funds. It would probably update the capital improvement program. It probably would not be a change to the base reuse plan. I don't think that is necessarily required. It can be part of the capital improvement program. The tricky part in terms of transitioning has to be the concurrence of this board that as a policy matter, they are committed to completing the capital improvement program and all of the items that are encapsulated in there. I think that would be the current thing. And there's also a legal mechanism that would go hand in hand with that in order to accelerate blight removal. And we are going to get to this. I've got a couple of slides on this later. Michael kind of jumped the gun a little bit. But FORA could encumber all of its tax revenues, issue debt now, and encumber its tax revenues going into the future to pay for that accelerated building removal. And there is a cost to that because some of the jurisdictions' analyses have included a return of some or all of that tax increment either to the county or to the city of Marina, who's got has encumbered portions of their tax increment to pay into the future for their bonds that their work that they've committed to do as part of that. So those are still at play, and they could be encapsulated, I think, as part of the transition plan, which is why we're bringing it up now as part of that, even though we're a little ahead of the administrative committee bringing forward a more fully completed and comprehensive program with the financial analyses and assessments and things that need to happen.
Thank you. Ms. Morton?
So, yes, while this board can change the policy and say that blight removal or building removal is going to be a higher priority in our CIP budget, the difficulty is that the Mello-Roos CFD is the biggest generator of the funds for the CIP. So next year it was anticipated we're going to get 2.9 million roughly in tax increment. 1.3 million of that is by policy decisions used for the overhead costs in our general fund, which means 1.6 million is going to be put into the CIP, and the priorities are set annually by this board on how that gets applied. The CFD cannot be used for building removal, blight removal by law. So that 1.6 million has to go into other improvements, other policies, the roads, the water augmentation, other things. So we can change a policy, but that doesn't mean we have the money. So currently, the board has roughly $9.6 million committed by policy. We've committed that we have to do two things. We have to give the city of Seaside money to take down buildings in a flat fee, and we are committed to the city of Marina to take down the stockade, which is a project, which we have, at this point, we might have an estimate, but we're not exactly dollar exact. But let's use the sum that's in the staff report or in the transition plan of 9.6 million. Additionally, we're on a contractual obligation to Marina Community Partners for a total of $44 million in a reimbursement agreement, which they haven't taken title, take down they call it, but I call it transferring title. The Marina Community Partners is already contractually obligated to remove blight, remove the buildings on its properties, and FORA is obligated to reimburse them for the actual cost up to $44 million. The two remaining transfers of title in Phase 2 and Phase 3 are only going to generate a portion of our remaining contractual obligation. We have a shortfall of $2.75 million, which is not addressed in any of this transition plan. So let me just use the sum $3 million so I can make my math easier. But you basically have about $13 million that we already need to fund. If you look at our budget in 2018-19 and look last year, we had zero coming from land sale revenues. We're not anticipating land sale revenues. So if I don't have land sale revenues to do this $13 million, that now I want to make that $20 million or $30 million, where's the funding going to come from when we can't change the CFD? So while we as a board can make policy decisions, I think everybody here would raise their hand and say, yes, let's get rid of this blight. We've created past decisions, or the state law has created restrictions on how we can fund to get this done. So to your question about amending a base reuse plan, if I don't have a funding structure to do it, you can put in all of the language that you want to. What do I have? Land sale revenues going forward. Will the balance of the land sales, not what's already been sold, pay for the building removal? That's the anticipated cost, which initially in 2016 transition memo of January 16, 2016 was estimated to be $54 million. I think the most recent number they put in front of us is $94 million. And the price per acre that we think we would get is $180,000 fair market value per acre if it's clean. There's no funding mechanisms. So while we can spend a lot of time on that, I just want to go through that clarification that everybody really understands. What the limitation is finances.
So I do have to correct a couple of factual issues. First of all, with respect to the Marina Community Partners transaction, it is addressed in this transition plan. That contract is assigned as a part, or it's proposed to be assigned. But more importantly, by contract, that contract, if there is any gap, falls to the Marina Successor Agency by contract. So it's a contractual provision in that contract. It doesn't address who raises the money, but the obligation is already there, both contractually and in this plan. So that is addressed, and that those documents are currently in litigation. So I don't want to go too much into detail about that, but it has been addressed. And then with respect to the funding sources, many of those are policy issues. So for example, the way our capital improvement program is built, the tax increment, the extra tax increment above what FORA retains for operations, rolls into the capital improvement program. It rolls into the bottom half, what I call the bottom half, or the unrestricted funds piece of the capital improvement program, and that's primarily building removal. Anything that is left over from that in terms of land sales, property tax increment, rolls up currently into the top half of the community facilities district fee, and it helps keep those community facilities district fees a little bit lower because it's providing funds that then don't have to be generated by the developers. So that's how it works now, but that's not to say you couldn't change how that works. So instead of rolling those fees up, both in terms of land sales or in tax increment, you would encumber them as part of the bottom half of the capital improvement program. It would be used 100% for your building removal obligations, which would be increased in your capital improvement program. So, and then there was one other point that I needed to clarify for you, and I have now managed, I guess my brain's getting old too. Oh, shucks. I can't remember exactly, but it'll probably come to me in about 10 minutes. Sorry.
When it does, let me know. Anything else on policy enforcement? Any other comments? Okay, let's move on to the next key consideration, which is the implementation plan. And again, this touches on 3 possible ways of agreement, basically. either through contractual assignments, through agreements, or through agreement that is imposed through litigation. Comments on this section? No comments? Okay, then what I would propose is that we move on in the discussion. Again, keeping in mind the fundamental key issues that we just reviewed. But let's go back into some chapter discussion, starting with administration. And do you have a slide on this one?
I do, and I've got great news for you. There's nothing new from the June 8th presentation. What we have are the key issues. So what we're hopeful to have discussion about, as appropriate, are trying to answer some of these key issues about the CalPERS liability, who and how we handle that, who manages the LAFCO real party and interest litigation on the transition plan, if there is litigation that involves that. It sounds like it's very possible, given the request for legal interpretation. You know, it's almost impossible for two lawyers to have exactly the same interpretation. So I'm anticipating that there could be some litigation regarding that. I see drew a couple of smiles. That's good. Who assumes the responsibilities if there are settlement agreements or court judgments? You have two parts, and I think it's recognized that there are, I think Supervisor Parker raised the issue about ESCA and her interpretation. There are some things that are just bigger base-wide and will remain base-wide obligations, and then there are going to be individual jurisdiction obligations in the scenario that she's outlined as her vision for transition planning. But it begs the question, who is going to be responsible for managing those if there's litigation involving those base-wide obligations, whatever they are, whether they are just the limited handful or if they are the entire capital improvement program and the entire program. Can or should FORA seek extension of its insurance policies to provide gap or statute of limitations coverages, and who maintains FORA records? So as part of our discussion last time, we also gave you a set of some suggestion or some considerations, and that's where I'm going to stop on my presentation.
So, comments. These are suggestions. These are considerations for the board to discuss, give some indication on policy direction. First suggestion is, I'm filling gap here. Okay, Jane, I'm sorry. Ms. Parker, do you have comments?
Thank you. I had a question. So, talking about legal liabilities, what has been the discussion about setting up a fund to take care of litigation issues that arise related to FORA that may linger, may not be decided yet when FORA sunsets?
From a budgetary standpoint, your FORA staff has anticipated, and LAFCO has requested, that we establish a indemnification fund to cover those kinds of contingency. I think it's a little bit of a broader question, though, than just simply LAFCO litigation. It may be that as a transition plan matter, instead of it being solely a indemnification fund for LAFCO, that it becomes more of a litigation defense fund, perhaps, for other kinds of litigation that might be broader in nature. But we still would need to address the who manages that, how any kind of litigation is managed, and those funds administered, because just like the capital improvement program, I suspect that there may be some potential funding shortfalls. You know, we are good planners, but I can tell you sometimes, you know, the fees just aren't enough.
Senator Money.
Thank you. So just on this issue, you're addressing protecting resources for that potential indemnification or litigation, but who then has the authority to enter into a settlement agreement, for example? Who has authority in that successor? Establishing a fund is one thing, but who has the decision-making authority in that litigation?
And that's exactly right. That's the question that I think I'm raising. I don't have all the answers to that, but I think that this transition planning process, as you move forward in the way it's been outlined and what I've heard today, it's an issue that needs to be addressed. So your staff is planning a fund, has money, you as a board have set aside money in your budget for that, and then transition-wise going forward, who has the authority to settle lawsuits, who has the authority to dip into that fund? Are there going to be limitations as to what kinds of lawsuits are allowed to be reimbursed from that fund? Is it only LAFCO? Is it Habitat Conservation Plan litigation? Is it a road network litigation that might not be managed by any of the jurisdictions, but maybe it's managed all or in part by TAMSI? You know, there are still some issues that we need to address moving forward on that.
And in that, okay, excuse me, Ms. Morton.
So many of these issues were discussed at the Transition Task Force. And for CalPERS liability, it's anticipated that we would get, and Helen's the expert on this, but that we would be getting a final bill. And let's say that final bill is $8.6 million. Is that we, as the Finance Committee, as the FORA, would say we've already set aside roughly $7.6 million, and that we need to budget the additional sums. So we are guessing, better than guessing because Helen's very good at this, what that liability will be in June of 2020, and we have earmarked funds to satisfy that. Now, the problem is, what Helen says is PERS isn't always the exact science, and there might be a variation, and there'll be a bill that comes afterwards. So maybe you do a retention of 10%, and we put it in our client's trust account, and when that bill comes in, he writes a check. It's funds in the public trust. It's held in his trust account. We all do this in our real worlds. So that one doesn't seem to be too hard. Can we go back one? Did you change the slide? Administrative liabilities, PERS obligations, FORA should assign insurance
I just want to
policies.
make sure that you're thinking and really read. You want to go back to the questions?
Well, I'm trying to say that the Transition Task Force
On the
has
key
talked about
issues.
some of this stuff going forward, about the distinction between what is the judgment. Number 3, who assumes responsibilities under potential settlement agreements. I'm going to use a past litigation, not to cast aspersions on anybody, but we were sued, FORA was sued, for that board decision to approve a project in violation of CEQA. And we paid a significant $2.75 million as a settlement. City of Marina is not responsible for violations of CEQA that are done by this board within the exercise of their jurisdiction. Those, I don't know how you protect against those. If FORA is gone, there's no funds. I mean, a lot of companies filed bankruptcy. PG&E right now is trying to shift the responsibility to its ratepayers. There's a lot, we have to figure that out. But there is no way as a jurisdiction that anybody, I see everybody's head agreeing with me, that we're going to take that on. That's very different than a contract that you have in place that is an obligation that you have to fulfill going forward contractually, is that if the contract is assigned to Marina, I am responsible to fulfill that. If litigation occurs out of that and I didn't fulfill it, I'm the responsible party because I took the assignment of the contract. The liability insurance, I think it's very smart for us as an agency in our budget to buy workers' comp insurance for the statute of limitations period. We sunset 2020. What's the longest statute of limitations for a worker to file a claim, pay for that insurance before June 2020? The insurance is in place. You have an attorney that handles it for the entity. None of these seem huge or problematic. The PLL insurance, we've all already bought it. We all bought that policy, and the county agreed to manage that policy, and that was in many years ago, 3-4 years ago that we did that. So this is not something that we just need to pull it apart and do each task and either put it on an agenda, but we can't just lump together and torment ourselves.
So I think the suggestion about putting aside a 10% retention, this as an example for the CalPERS liability, would be a little bit different than what this board has said previously. So what this board said previously is if there is any gap between what we have as available funds to address this liability and the CalPERS final terminated agency unfunded liability, which we've tried very hard, everybody has tried very hard to make sure that that number is zero, that we are able to pay 100% of whatever CalPERS can throw at us. We said, though, if there's a gap, it gets allocated administratively based on voting percentage on the board. So setting aside a retention fund would need to be an additional board policy to govern that contingent liability.
There was also a comment on this side of the table that I missed. I'm sorry, I don't know, Ms. Carbone, was it you or, okay.
I think
To the other side of the table. I'm sorry, I just blanked.
That's okay.
Was it you first?
Yes.
Okay. Go ahead, Mr. Rubio.
Who's next?
You.
Okay, thank you. This idea of continuing vulnerability to lawsuits is one that I brought up at the Transition Task Force. While the PERS liabilities and some of those are pretty well defined, I think we find ourselves in a situation where we're more vulnerable to the types of lawsuit that you were talking about, the sequel lawsuits for the full board actions. And those may continue based on the transition plan. And I really don't, to me that's really scary because those tend to get pretty big. And those obligations should be carried out by the regional responsibility, not by any one entity, but it needs to be figured out how we address that, because while we terminate in 2020, that litigation can go on for 3 or 4 years, or 5, depending on what the issue is, and how do we sustain a legal defense for over that kind of time, and who's going to manage how that is addressed, the closed sessions, the strategizing, all that is a really big, to me, one of the biggest questions that we have.
Mr. Udelon?
This must be Friday the 13th because I find myself totally in agreement with Director Morton. And that is, I know in the past we've had discussions about trying to meet the CalPERS obligations as of 2020. And I think the way the discussions have been going on, we'll either totally disband or whatever goes on will be the 5 land use jurisdictions with CHUMB and maybe MPC. But in any event, we cannot afford to have any CalPERS liability in June 2020. To me, I've been on the board for a long time now, and the hardest working members of the board, the most valuable members of the board that we have here are the members representing the non-land use jurisdictions. They don't have any skin in the game. They show up, they have a higher attendance rate, they work their tails off, the contributions they make are esoteric, are to the point, and they've done a heck of a good job. I'd like to see them continue, but I think the handwriting's on the wall. They're not going to. The last thing we need to do is at June 2020 say, hey, thanks for all your service. And by the way, here's a bill for $10,000, $20,000, $100,000 because we didn't meet our CalPERS obligations. When we're looking at obligations of $40 million for HCP, $100 million for this and so forth, an extra $1 million here or there put aside in a trust fund or whatever and saving it there so we don't have an obligation after 2020 is the only way to go, and it's the only fair thing to do.
further comment?
Just a question. So if a litigation fund is created, is it possible that the larger you make that fund, the more likely you will attract litigation and litigants, and the harder they will work to?
You can make the check payable to Sherry Damon. It's part of my legal defense
Okay,
fund.
very good.
Just teasing.
Thank you. I'm going to ask to change the order of something right now. My understanding is that Senator Rawani is going to have to leave us shortly, by noon, actually. And I would like to move us to the discussion of building removal. So unless there's an objection from any board member, can we please move in your packets to more towards the end, page 16, sorry, page 16 in your packet. Sherry, if you could bring up the building removal.
All right. Building removal. Are you ready? Can I just go?
Yes, please.
Okay, good. So I thought it would be helpful to roll out this chart again. We saw this chart the last time on June 8th as a way to kind of analyze what we have and why we're doing it. And so I thought I'd put together a little something for building removal as part of that. It's what are we doing? Why are we doing it? Can it be completed prior to 2020? And what are some of our options post-FORA? So as we already discussed, building removal is a policy decision. It's a base-wide, so what's been designated by FORA is base-wide. And so there are two pieces to it by policy. One is base-wide, and we're paying for that in the capital improvement program, but then there is the other part that we have all been talking about. Why? We do it by policy and we do it by contract. There are more than one contract related to building removal. We've got the Marina Community Partners one, but not many people recollect that the county East Garrison project also had a building removal contract as well. So there are more than one contract that relates to building removal. But we are talking about transition leaving individual jurisdictions with additional building removal. Timing. Could FORA's portion of building removal under current policy is anticipated to be completed prior to 2020. That would include the removal of the stockade, and that would include the part of surplus 2 that is in the city of Seaside. But a new program probably would most likely not be completed prior to 2020 to remove all of the buildings. And there are some pros. There's a regional benefit to removing all of the buildings that have been called blight. They may or not, I remember what the other point was now though, and I'll get to that. CFD. There are some pros from a regional benefit. So enhanced property values, not only of the property where you're removing those buildings, but also the surrounding areas. You have enhanced vistas. I call that visual blight. You have a removal of the visual blight. That helps make this area more attractive, both for our visitors here and our potential future developers here. You have a reduction in potential hazardous materials situations. You have a lot of buildings that have hazardous material contaminants. You have public safety, caretaker type costs, public safety encampments, things like that. Some of the cons, though, are it encumbers property tax. A program would necessarily encumber property tax revenues and land sales revenues that the jurisdictions might want to devote to something other than a base-wide program to remove all the buildings. So you have a couple of options here. One, do not change anything, just as part of transitioning, the underlying jurisdictions get what they get, and they're going to have to solve the problem either by reducing land value, coming up with some creative tactic or financing mechanism, whether that's development fee, reduction in land sales. And here's the point that I meant to correct. With respect to the Community Facilities District, technically we can remove some buildings. There's a caveat. You can only remove those buildings that support or are incidental to a facility which will be in existence for longer than 5 years. So for example, the buildings along Second Avenue, we were able to use Community Facilities District fees because the infrastructure was in play for longer than 5 years. And that's how you use a Community Facilities District to remove some of your buildings. So your consultants, when you're thinking about that, you should be thinking about that. But Melrose does have a provision to allow hazardous materials removal, but it keeps the limitation that you can only do that if you're replacing it by a facility, a public facility that is in existence for longer than 5 years. And not all of the buildings out here will be replaced by public facilities in existence longer than 5 years. Whoops. So these are your key issues, and this is what's included in your board report for July 13th. Should the remaining FORA obligations for building removal be assigned to the underlying jurisdictions? Right now, we have said, yeah. Or should additional building removal be undertaken by the FORA board, which would require revision to existing policy, and designate additional building removal now as a base-wide cost, which would then put it in your capital improvement program, and we would have to decide how to handle that as part of the transition planning process. If yes, should FORA Act be extended as part of that plan to address that or transition that? Or finance accelerated building removal, or staff directed to bring back a more concrete program to accelerate building removal with additional transition plan recommendations. So even if you weren't able to do that kind of a program in the next 2 months or 3 months before, let's say before December of 2018, when this draft plan is there, you could, as a planning mechanism, say any plan or program which will be adopted by the FORA board, we all agree as a transition planning point that it will be included in whatever the final CIP is as of 2020, and that is what will set our obligations under the transition plan. So you could build in some contingency language into a transition plan, knowing that you're going to get future programs coming down the pike to address issues like this. And that is where I stop on this presentation. I think Michael, Executive Officer Hulamard, outlined some of the discussions at the Administrative Committee. I have not been a part of those discussions, but I know many of the jurisdiction staff have started those and been grappling with this for a couple of months.
I think the board, this is a risky discussion because you're talking about something that the board has already made a couple of policy decisions, and one that's a sort of a standard in how you do a fair market appraisal, but the second being providing additional dollars. What we've discovered, the city of Marina in particular, but the city of Seaside as well, have discovered that that isn't enough to get the developer to go out and spend or borrow money to take buildings down. And as a consequence, we're left with buildings here that are not being removed, and it makes our community appear blighted. That's a problem that this board has wrestled with for a couple of years now. How do we do more? Well, Craig Malin and Lane Long and others have come up with some ideas, and I'm fearful that I bring this to you and we don't have the full package out for you to consider, because if there's a request to do some bonding against future revenues, or if there's an issue about how do we pledge these assets and all of that, that needs a little more financial analysis and professional support, which we want to bring to you later. But I think it's a policy issue that will certainly affect the transition, and it's enough of a policy question that you should at least be aware of it today. I know the senator has this concern as well, so I just wanted to put it out there without getting too far ahead of the administrative committee, which will advise you on this issue, that it's something that, as a policy consideration, I think I haven't found anybody that would have a disbenefit in trying to move this ahead, other than the risk.
And I'd like to offer an opportunity to Senator Monning, because I don't want to lose his thoughts before he has to leave.
Thank you, and again, I appreciate the reorganizing of the agenda, because this is, I know, an important issue to all of us, and regrettably, I do have to depart shortly. So I thank you for that modification. And again, just as a precursor to my question, I want to again acknowledge the amazing work of the FORA staff and all the board members for pulling together on what's really complicated stuff. There's so many moving parts. But again, it's getting it on the table and opening to this type of discussion, and it's been very helpful for me. A question I had, either for Sherry or Michael, in framing these options of either the jurisdictions just assume and absorb buildings that haven't been removed, or a second option, an extension of FORA authority to continue in that process. What is a transition option that might be a hybrid of an ongoing central responsibility, but not necessarily through a FORA extension? In other words, would Monterey County or LAFCO, assuming it's not being asked to absorb the liability, but get some appropriate compensation for managing that ongoing commitment to blight removal? Is that an option? Is there some third option other than the two that are outlined here?
You know,
yes.
some of this, Sherry's going to say yes, there are options, but I would start by saying that it is enough of a complicated discussion that I would want to add to the table the structure of how you manage it. To a certain extent, I would have to advise the jurisdictions with the kind of work we've done with building removal, there are some benefits with the kind of overlay and risk level that FORA has supplied in signing off on all of the manifests that go out. There's a professional obligation, there's a risk avoidance that the jurisdictions get by the fact that Stan Cook, for how many years, Stan? 20? And how many years have you been doing the manifests that come off of the Fort Ord, with respect to the Dunes project in particular, or? Okay, so nonstop. We have a working relationship. We've been able to negotiate, because of who we are with our state authority, different fees than the jurisdictions and others would have to pay. There's an option to be able to work with our local landfill to be able to do some of this for local revenue as well. But there's so many levels of complication. I wouldn't want to assert what those options are without looking at all the pieces of the structure. But yes, it could be the county that would take this on, but then is the county interested in doing building removal?
And then
No.
the other point, not
But-
for an answer today necessarily, but the option of some FORA configuration continuing to shoulder that responsibility and liability. Can you quantify how that could inure to the benefit of the local jurisdictions, not assuming that liability, that cost, that risk? Although the magic here, or the challenge, seems to be the catch-22. Developers don't want to invest as long as the blight is there. They want blight-free acreage before they're interested in purchasing. But again, not necessarily for an answer right now, but I think it would be helpful in framing some of these options. What's the relative cost or protection from cost to the local jurisdictions? That would be helpful, I think.
Yeah, I think we could do that, Bill, and make that part of a study that I think the
Sherry may
administrative
have
committee already
comments.
wants.
I want to hear Gail's comment as well. I know I started by saying we should look forward and not backward, but I really can't give up the opportunity. Hindsight's 2020. 20 plus years ago, we all thought we were getting a great deal when the federal government parceled off this land with the base closure. If we could have renegotiated those land transfers to some continued federal commitment to cleaning up their mess, we would not be shouldered with what we're dealing with today. So again, a little dig at hindsight, but our challenge, we're not going to change that. Our challenge is to move forward. I don't know, Sherry, did you have a comment on that?
I think
And then I want to hear Gail's.
Thank you.
Yeah.
I think Mr. Hulamard captured the unquantifiable, or another element that adds a layer of complexity. That I was just going to say that I think the structure and the financial, there's a financial assessment that has to happen to really put the pieces of this in play. And I think the elements that Mr. Hulamard has raised and that you've commented on as well, and others, about the risk, the cost benefit, that should be encapsulated with that study.
Is there a universal ballpark dollar amount to remove all the
There is,
buildings?
and I'm going to turn it over to Mr. Brinkman.
Yeah, with
Ms.
the,
Morton, I'll get to you in just
just
1
a
minute.
quick
okay?
answer, what the administrative committee has been looking at for the remaining buildings is 46.8 million.
Thank you. Thank you, Madam Chair.
So,
Ms. Morton.
yes, the difficulty that I think the senator has hit it exactly is, what is the hybrid? So for us in the city of Marina, who has all this blight, this is creative thinking and coming up with a mechanism to fund it. So basically you say, we're going to give our tax increment, we can issue bonds. So between now and 2020, we can generate the funds and hire the contractors, and FORA can do the manifest, and we do as much as we can get done by 2020. The difficulty going forward after that is that if FORA continues, when I go to sell, that I've taken down my blight on Cypress Knolls, that my property that's now worth $10, the net of taking down the blight versus what it would be worth, and I give FORA $5 and I keep $5, now is worth $180,000 per acre. So now I'm giving FORA $90,000 per acre, but I have to service that bond payment with my tax increment into the future, and FORA is not absorbing any of the cost that increased the value. That's not equitable. I'm thinking that's silly. But if FORA discontinued and I wasn't giving away 50% of my land sale value to commit my tax increment into the future, because now I get to keep the $180,000 per acre for its improved value, and my tax increment goes to pay for the burden that got it there, that's fair. So what's the hybrid? The hybrid is we don't continue FORA. Let's look at 2012. RDAs went away. So now the state Department of Finance decided which redevelopment agreements are we going to continue to honor for tax increment. And one of those is my Marina Community Partners property, that we basically give them $191,000 of tax increment from FORA. When FORA goes away, the city of Marina's tax increment is going to go from the county assessor's office, where they collect it, to that obligation. It's not going to come to Marina, it continues. So the key financing question for me would be, in essence, this is a redevelopment agency. If you enter into a like contractual obligation, would the state allow us to continue to take the tax increment that we pledged to pay those bonds? And if that were the case, and the city of Marina gets 100% of its land sale revenues, this might be a spectacular idea. But that is the hybrid that would have to happen for Marina to get behind this.
And if I could just react, because I can't predict where the state would land on this, but it spills over to some of the other questions of extension or hybrid. Every other jurisdiction in the state lost their redevelopment agencies, and we were able to keep FORA and get a FORA extension. But the questions we faced at that time, and Mayor Rubio was there, and Executive Officer Hulamard, when we spoke to these committees, the members who don't have a vested interest, who don't touch Monterey County, say, why should we support you having this when we don't? Well, our answer to that is, this is a unique beast, and it was different than other community redevelopment agencies, and it was dealing with the economic impact of the base closure, and continues to deal with that, not just economic, but now environmental et cetera. So I think maybe a little bit long-winded, but one of the challenges moving forward with any state solutions is that we don't have a magic wand and potentially face resistance from either Department of Finance or other legislators if they think we're doing a backdoor effort to give our constituents continued redevelopment agency status. I'm sharing the dark side of that. I think we can fashion a strong argument. It's just there's risk and there's no guarantee of where Department of Finance or the legislature would land. But framing the option at least lets us do some early exploration before we commit ourselves to something. So that's where, again, I appreciate the opportunity to kind of surface this in all of its complexity. It's taking possible options and breaking them into other options, or how would you implement it? What would be necessary to move from here to there? And maybe if I could just, before I bid you adieu, back to Mr. Hulamard and to Sherry for FORA, the amount that's earmarked for clearance by 2020 or into 2020, how would you quantify how many buildings that is, or financial obligation?
It's about $10 million, and I think it's 27 buildings in Seaside, Stan?
Right.
17 in Seaside and 7 in Marina.
So it's a total of 25, I think, right?
25.
There's 17, 7, and the little one? So it's either 24 or 25
Right,
buildings.
and again, the universe of the number of total buildings?
I'm not sure the number, Jonathan, but it's 46.8 million additional dollars, I think.
So that number of 46.8 million includes about 300 buildings.
So plans for, what was the number, 25 plus 7?
The 24 buildings is about 10 million. They're predominantly concrete buildings in Seaside, which are very expensive, and a big concrete building in Marina, which is very expensive. Typically, a building is running 70, 80, 90,000 a copy when it's World War II wood. Could be as much as 120 when you have the larger buildings, but in that range.
Thank you. And then, again, that total universe of the number of buildings?
Approximately 300.
300. Okay, thank you. And again, I apologize for my early departure, but this has been tremendously helpful, and I do, again, extend the invitation for any and all stakeholders, FORA board members, community members. Please feel free to follow up with our office with questions, comments, recommendations. This is the time for us to get all options on the table and then make the best informed decisions we can. So thank you all. Happy Friday the 13th. It's been a good one. It's bad news for the naysayers, okay?
Thank you, Senator Monty. Sorry that you are having to leave. Any more comments on the building removal? Yes, Ms. Garfield.
Thank you. It sounds like there's a lot of things to find out about feasibility, but so to what extent do the bond issuers need a continuing known business entity to be the party that is responsible for the loan? I mean, I just cannot see anybody issuing a bond for an agency that's then going to go away. So we really need to know what the terms would be and what would need to be in place to what extent to have a bond issuance be done without an enormous risk premium.
That would be part of what we'd bring back.
Are there comments? All right, very good. Thank you. Let's go back where we were. Again, keeping in mind the overriding considerations, which are the economic recovery, revenue generation, revenue sharing, policy enforcement, and
Candy?
how the implementation
Candy?
plan actually takes
I
place.
think everybody's kind of ready to have lunch. They're,
Ready for lunch.
yeah.
12 o'clock.
Hold that conversation. Let's have lunch.
Thank
An
you.
hour?
Thank you for your intervention.
Is that good?
Yeah. Well, I think everybody was getting up.
Great.